my everything, yeah. My everything is you, Lord. Yeah. Ha-ha. Oh, 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 oh. Everybody say, how can I express my gratitude for all the many things you've done for me? Words are not enough, yeah, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things you've Father, you done for me?
It's another wonderful time to be alive. This is another edition of the Community and the Law, brought to you by BWF Solicitors.
Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specializing in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello, it's another wonderful experience we're going to have. Saturday is here with us again, and we are live with you on the program The Community and the Law. My name is Riku Frimpon, and we're live on BWTV, and we're doing this courtesy BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors, located on the 4th floor of the Honor House, 214 to 218 Tottenham High Road, Seven Sisters, North London. They are a law firm that understands what you really want to have and what is good and needful for you. So I'll advise you to visit them. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Call them on 0208 493 7340, or in emergency situations 077 127 61884. Hello again, and welcome to another edition of The Community and the Law. Now, this afternoon, we are going to look at what has happened and what's going to happen for the second part of the year 2025. The Home Office have introduced new and significant changes to the skilled worker route, and is beginning July 2025. And we want to look at how it's going to affect those already here in the UK. You wouldn't want to miss this for all the good at Obuasi, would you? No. And today we are so privileged to have the main man himself, the senior partner of BWF Solicitors. Now, you know, when it comes to the skilled worker route and the changes that come with the immigration, the COS, and all the occupational lists, he is a master of the trade. So changes have come, and he has decided to sit in and let us in on whatever there is that you need to know. So call somebody to call somebody and tell them that we're live on BWTV to bring you The Community and the Law. We're looking at changes that will take effect in this month, July 2025. So with your permission, let me welcome the man himself. We have so missed him actually because it's been quite a while since he's been on the program. But you know what? Sometimes when it's needful, we bring the main man to support us. And maybe on his behalf, I will say thank you to the other partner and lawyers of BWF Solicitors who've held the fort while he's been away. But he's back and back for good. Uncle Ben, good afternoon and good evening. And maybe good morning because we haven't had that to say to you for a very long time. We thank God that you are here with us.
Thank you. Thank you very much, Kwaku. And thank you to the team. It's been an experience over this last, I'll say about 6 weeks that I've been away. You know, I had to take rest, a natural enforced rest, whether you like it or not.
Yeah.
You have to take the rest, and which I've taken. And I'm grateful to the many people who've supported us over the last 6 or 7 weeks, especially my colleagues from my co-partner, Eunice, through to Charles, Theo, Cynthia, Sandra, Abigail, Annie, Pamela, Emmanuel, Adai, Chelsea, Deborah, another Emmanuel, and all the team, and Kweku, especially you, that without fail every Saturday you've held the fort and supported the community, and also to the community for their continuing support over this few years. We're grateful. Now, when the changes happen, we have to try and break it down in bite size and see whether we can capture a theme which will help people to explain it better. Because as we will find in the next few minutes, the changes are broad and significant. And it's important that we capture the theme that informs the changes so that it stays at the back of people's mind. And we do this to also prevent unscrupulous people taking advantage of our community members and giving them false information, misleading, trying to take their money. Because when someone is desperate, they do desperate things sometimes without being minded of the consequences of what they're doing. So once again, thank you, and it's good to be back.
Well, it's good to be back, and it's good to have him, in fact, next to me, because it exudes that kind of confidence I need to have to present this. So those of you who have joined us, I want to welcome you and say thank you to you. But you know, you have to do the rightful thing when you join us, like the page, share the program, and also invite people to come in. If you are new here, what I would advise that you subscribe to the page so that whatever content we put on, you would not be left out. Well, updates have come, but there are a few other things that we need to do. BWF Solicitors is a family. It's an organization that really supports the development of staff and the community as well. And every month we make sure that we look at what people have done within the organization and honor them accordingly. Our employee of the month is our trainee solicitor, Frank Ano. Frank has been doing quite well. You know, most of the Thursdays he comes on our program and he delivers so very well. Sometimes people think, oh, they call him lawyer, and the rest of it. Now, he is a trainee solicitor who will very soon pass out and become a very wonderful, astute lawyer as we always want him to be. So, Frank, congratulations for being the employee of the month. We salute you as we do to all the other employees. And I believe this year you've won it twice or so, thereabout. That shows that you're doing quite a good job. So thank you very much. Congratulations to you. So viewers, clients, friends, and loved ones, let us all celebrate Frank for the good work he is doing. Employee of the month of June 2025 for BWF Solicitors, we have Frank Ano. Congratulations. And then we also encourage you to give us the feedback that we always want you to do. And you have been doing that. People have experienced the services of BWF Solicitors and they're grateful. And I can say with all the confidence in me that every week I have loads and I would have to choose one of them to bring onto the show. And this afternoon, I am looking at what Ruth has said to BWF Solicitors. It says, thank you, my lawyer Annie at BWF Solicitors. My application was successful. She explained the whole process and I understood precisely what needed to be done. Thanks so much, Annie. I am grateful. Annie, Ruth is grateful, and we're also proud that you do your work so diligently well and you achieve the success that people expect from BWF Solicitors. So, Annie, Ruth is grateful. We're also happy about that. But for this, I would ask people who come under the tutelage of BWF Solicitors always do quite well. Uncle Ben, let me ask this. Annie is doing well. I think at a point I kind of pushed her to be sitting in my seat, which she did so very well. I'm so proud of her. When you hear and see feedback like this, what do you say?
Kweku, the training here is rigorous. And, I don't envy myself at all because I'm sometimes seen as a stern father who comes with a carrot and a stick, and sometimes just a stick. And everybody will tell you that, I take my training seriously because you are going to diagnose problems and then you're going to treat it just like a doctor. So we have to make sure that whatever you're doing, the knowledge, the content, the confidence, and the advocacy is there. So she's a young woman. I think Annie is about 25, if maximum 26. So she's one of the cohort of people who are in their 20s. We've got, I think, 4 or 5 of those, both here and in Ghana, and they are very sharp people, very, very sharp. So I push, but also it's just like a sponge. It should be able to take water and not only just take the water, but also use the water and the soap to clean the plates or do something else. And clearly that's what she's doing. It's very important that, when somebody does well, you highlight what they've done positively and also encourage them, because what that does is that it also encourages someone that, oh, if I do this better, I'm going to be rewarded. And when you see employee of the month and all this, it comes with a reward. So they get money reward. Oh yeah. They do get money reward, and I'm sure most of them will say to you that being recognized or a client giving a good review about them is quite important. So we encourage that. Thank you very much, Annie.
Well, coming from the man himself, thank you very much, Annie. I know you keep doing what you do, and you will definitely see the rewards. We pick up our nugget. I keep saying that you watch out for that on our social media platforms every Monday before noon, and then we'll bring it up again on our Community and the Law program every Saturday afternoon and look at that in detail. This afternoon, we're looking at applications for entry clearance to the UK or leave to remain in the UK as a spouse of a person present and settled in the UK, and what you must meet. Now, it says that applications for entry clearance to the UK or leave to remain in the UK as a spouse of a person present and settled in the UK must meet relationship requirements. One of such requirements is that the couple must have met in person. A spousal application will be refused if the applicant cannot prove that he or she met the sponsor in person. This is from paragraph RWP 6.1 of appendix relationship with a partner. People meet people on social media platforms, they form relationships. But for purposes of immigration here in the UK, the law is saying that you should have met in person. Is it literally that, or what it is, Uncle Ben?
Yes, so the requirement of having met is inbuilt in the immigration rules under Appendix F, and is one of the major requirements that you have to meet if you want to go and bring your spouse here. Of course, if you're both here, it's assumed that you've met. So it's a mandatory requirement, and if you haven't met in person, then it becomes a problem. And having met is not meeting on social media or maybe on YouTube or something like that. It's just meeting in person physically. Yeah.
Okay. Right. So then we will look at the scenario of my friend who is faced with a conundrum, and I believe that we can help. Ahmed lives in Dubai, whilst Amina lives in London. The two met on a dating site in January 2024 and started a relationship some 5 months later. After a period of chats and video calls, they soon discovered that they both come from Ghana and have a lot of things in common. Excited about their common heritage and desire to settle down in marriage together, they informed their respective families in Ghana about their intention to marry. In March 2025, they married under Ghanaian customary marriage laws, and they were issued with a valid marriage certificate, so to speak. They also obtained a statutory declaration by their family representatives, a letter from the Judicial Service, and the Ministry of Foreign Affairs in Ghana. Despite their desire to meet, the couple have never been able to meet in person, nor were they able to even attend the marriage ceremony. As Amina has indefinitely lived to remain in the UK, she sponsored Ahmed's application for a spousal visa so that he could relocate to the UK for them to start a family. The application is still pending. So then the question I'm asking is, what will be the likely outcome of Ahmed's application? Now look at that vis-a-vis the nugget we had just a moment ago, and Uncle Ben explained that applications for entry clearance to the UK or leave to remain in the UK as a spouse of a person present and settled in the UK must meet relationship requirement, and one of such is the requirement that you should have met in person. So a spousal application would be refused. Am I answering the question? Well, I'll leave it there and ask you to think about it. So what will be the likely outcome? There are four options here which I want you to consider, and I'll come back to it at the later end of the program. It will be granted under this FM because he is a spouse or someone with indefinite leave to remain in the UK. That means that the person is settled, okay? One likely outcome would be that it will be refused because they did not obtain a letter from the Ghana embassy in the UK. A third one I've given you for you to consider is that it will be granted because their marriage is valid in Ghana and so accepted here in the UK. Or the fourth one, it will be refused because Ahmed and Amina have never met in person. What do you think? Test yourself with this, and when we come back, I will be asking you to give me what the likely outcome will be. And then I'll run it by Uncle Ben to let him tell us what the correct one will be. So think of the nugget, think of my scenario here. Ahmed, who lives in Dubai, and Amina, who lives in London. They've met on a dating site. They have gone to the marriage ceremony. They've done the needful, yes. But will the application be successful? Ask yourself, think about it, and come back with it for me. Well, with this, I will take a quick break, and when we come back, we get into the discussion. We are discussing the new changes that will take effect in July this year, 2025, and how it affects those who are already here in the UK. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, welcome back, and thank you for sticking around. It's still the community and the law, and it's brought to you by BWF Solicitors. Those of you who have joined us and have shared, I want to encourage you to continue to do that. And let me take this opportunity to quickly welcome you. Tilly is here as usual. Please kindly share, comment, and like. Thank you. Thumbs up to you as well. Could you for a new beer? What does that mean? Uncle Ben is the best. Okay. Well, Anita Japoma Japan, it's good to see you back, Uncle. Yes, it's always exciting to have Uncle Ben himself back on the program. Quality for Uncle Ben, looking good as usual. Yes, evergreen. Obviously, I think now I can agree that I have to retire him because I've got a good bunch of lawyers, trainee lawyers, and solicitors behind him. And now I can agree that he can take his rest. He's done a lot over the years and he needs some rest as well. Let's share the money. Congratulations. Keep doing what you do. Frank. Oh, okay. You want part of Frank's money, but he's doing what he's done. He has his reward. Anita, I don't think you have played a part in it, have you? Anyway, well, Gifty Achai team, good afternoon, everyone. Gifty, how are you? I know you're doing quite well. So thank you for being here. Promise, share, 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 and share. That's the mantra. And I believe we're all doing that. Pick up the link and share with others as you come along. Anastasia Sapon, good afternoon. Good afternoon, Anastasia. How are you doing? I believe you are doing well. And today's topic is going to benefit everybody. You would also benefit from it as well. As I say, both looking smart with leaning long. Oh boy, Alex, is that what you can see? Anyway, you see, my big brother is around. I have to look good because he is a man of style. And when he does it, you have to copy the right thing. Don't copy from the wrong thing. Don't go to the cardboard lawyers because they don't give you anything. Well, thank you very much, all of you. So yes, now without much ado, let's look at what changes have been introduced, especially in the skilled worker route area, and how it affects those who are here. I know my dear friend Annie SL of Hamburg, Germany. This is going to answer the very questions you posed to me earlier in the week. And I didn't answer you because I knew I wanted you to join us. So those of you who are having all those questions, sit back, relax, because Uncle Ben is here. Uncle Ben, changes in the skilled worker route.
Yes. So what we have, so I'm going to do a bit of update, house cleaning first.
Okay.
So on Tuesday, I started work, got a video. The video was to the effect that, there's been changes and everybody was panicking. This is coming from people who are lawyers. So it was quite disturbing. At the time, I had a client. So I sent a quick response. I said, don't worry, I'll do that. So, I had to pull a camera and everything and then do a response, which I did, which was posted on YouTube the following day, and TikTok the following day, just to calm everyone down. And that has achieved significant results. So that's very good. There is a white paper, or there was a white paper. And as we always explain, the white paper is not law, it's government intention. The intention is to then bring laws to underpin the white paper.
Okay.
Now, some of the things that the government said in the initial white paper in May which has now become a statement of changes, which is a 997. We will go to that. That's our main topic today.
Okay.
But the update is what we're showing. And then we had another white paper. And within a few days, it became a statement of changes dated the 24th of June, which is, I'll say about a week or so ago. And this is what is causing, this is what initially caused the panic.
Okay.
So when we scroll down a little bit, we go to, just stay there. When you look on the left side, all the changes that need statement of changes, and the statement of changes, as you can see from the preamble, is to change the immigration rules. So you see that it says statement of changes in immigration rules. And then the Home Secretary has made changes here in after, stated in the rules laid by them as to the practice to be followed, and it follows and it follows. But when we look at the extreme left, those hyperlinks will take you to the changes. I like this is it HMTL? Adai, you are the IT person. HMTL, because it's not a PDF, so it can take you to where you want to go quickly. Let's go to changes to part 8.
Okay.
This is what caused the problem.
Right.
And you see, my difficulty with two people who gave the misleading information, and because they are lawyers, I want to say that maybe next time they should read properly. So it may be that one person had the other, and they then went straight to this. And because they went straight to this, they then decided that this then applies to everyone.
Everyone, yeah.
Kweku, when you look carefully at the beginning, it says changes to part 8. And it says 8.1. And it says paragraph 284. Paragraph 284 is a paragraph in the immigration rules.
Okay.
And it comes under part 8. Part 8 of the immigration rules is about family. It's about wife, husband. It's about parents. It's about extended family. It's about adopted children, 310, 301 adopted children, Geneva Convention, non-Geneva Convention, sorry, Hague Convention, non-Hague Convention. And then it goes into that. Before July 2012, this was what we were using to do marriage applications, before July 2012. Okay. If you want to do a marriage application, you have to use part 8, paragraph 284, and then you write and write and write. When we go to C, it says that the leave, so it says that if you want to apply for extension, Kofi Kweku, let's look at the words carefully.
Yeah.
If you're applying for extension of stay, extension of stay.
That's what 284 says.
That's correct. And you look at the C, you should not be in the UK as a spouse, a civil partner, unmarried or same-sex partner of a relevant points-based system migrant or Appendix W worker. Both are not in use now. Points-based system is being phased out. Appendix W is now Appendix SW. So and let me choose my words carefully because I'm a senior lawyer, so I have to. If you're not careful and you're just reading this and you leave it there, and I think you might have to take my video off so that people can read it properly. And you're not careful and you don't apply your mind to the comprehensive immigration. Let me say this. Both the Supreme Court and the Court of Appeal have said that the immigration rules, the way it's been crafted, is very, very poor. They call it spaghetti rules, and they give it another name. Is it amoebic? And Kufkweku is the most difficult law to understand. So sometimes I get it when people make mistakes. But when you then follow up and say that because of this, skilled workers, students, and other people cannot marry in the UK and switch, or cannot switch to the marriage route, then it becomes a problem. Because we don't use this anymore. We use Appendix FM. And the only change to Appendix FM on this is, and I go down to Appendix FM.
So it changes to Appendix FM, yeah?
It only changes language. So it's Appendix FM. SE means specified evidence. What did it change? Evidence of academic qualification.
Yeah.
That's all it changed. It didn't change anything
else
in Appendix FM. Let's go to Appendix FM and show people what Appendix FM is. In the rules, let's go. That's what we use on Thursday. So you might not have it. You may have to go on the internet. I just want to do this quickly. The video is there. We've got both English and Twi. So we'll do the updates here, and then we'll leave that and we'll go to our main topic.
Okay.
Yes.
So there's a link for Appendix F.
No. So that's the change we're looking at now.
Okay, yeah.
So that's all we're seeing.
So, okay.
So part 8 is not Appendix FM. So let's go to Appendix FM.
Okay. Yeah, so that's what our incumbent is telling us now, that if you have to, I think my thing is frozen. If you are looking at anything that changes, July 2012, you said.
Yes, so the change starts 16th of July.
Yes.
And then we've got 22nd of July. So this is Appendix FM.
Okay.
Quickly, you can see what it is.
Mm-hmm.
What does it say?
Immigration Rules Appendix FM, family members.
And then under that, you can see family life with a partner.
Family life with a partner.
And then at the beginning, this is entry clearance. So let's go down. Let's go.
Okay.
Let's go. Just go until you get to eligibility leave to remain. Okay, we're starting. Yeah? Okay. So, yeah.
Section R, LTRP, requirements for limited leave to remain as a partner.
Now, when we read the other one, what did it say? It's application for extension.
Yeah, it was like application
for
extension.
What does this say?
This one says requirement for limited leave to remain as a partner.
There are two different words.
The word remain in itself says that the person could be here.
Absolutely. And this obviously means that you're making an application for the first time. Or the extension means that you've already got the leave and you extend it. Yeah. Let's not confuse that. I mean, I will do this quickly. The other thing that has been brought into play by the new appendix, HC 836 is the EU requirement. Okay. Now, when you make your EU application, you're supposed to have been here lawfully for 5 years. So they will ask you that you have to show 5 years residence. Mm-hmm. If your NI is picked up by the system, then you don't have to show too much because your NI will obviously show that you've been around. But in certain instances, people don't obtain their NI early. So they will ask you to bring documents. Normally, they ask you to show 5 years. Mm-hmm. They ask you to show 5 years because you have to show the 5 years. Mm-hmm. And if you don't show 5 years, they will say maybe you were not here. They will refuse you. Right. A lot of people have been refused. What the Home Office is saying now is that that's not fair. So the Home Office is saying that in any 5 years, we want you to show 30 months. 30 months is 2.5 years.
2.5 years.
So if you can show any 2.5 years in the last 5 years that you were here, mm-hmm. we will give you the indefinite leave to remain.
Okay.
For me, that is very, very significant. That is significant because it helps those people who at the beginning didn't have NI to work and therefore that didn't show. But in the latter years, they were able to start working, maybe in the first year or the second year.
So then at least instead of 5, you have enough to show because you have 30 months within that period.
That's correct. But okay. I must explain to everyone, it doesn't mean that if you're an EU person and you've married for 3 years, you can use the 2.5 to apply for indefinitely. You should have married for 5 years.
For 5 years.
But you can use any 2.5 years
of that period to show.
Okay. That is also significant. The next significant thing that I want to talk about before we dedicate our time to skilled workers is about children.
Okay.
There's a concession for adults between 18 and 25, which means that if somebody is an adult and they've lived here half of their lives and they have lived here lawfully for 5 years, they will get indefinite leave. Mm-hmm. Children under 18 did not benefit from that because most children will depend on their families on family roots. So when a child applies, they apply with their parents on a family route. When it comes to the 5-year route concession, which is now part of the law, it's no longer family route. it becomes private route.
Oh,
And because they were given because of the family route, it disqualified them. That law has changed.
all right.
So if you're a child and you are above 7 years and you've lived here lawfully for 5 years, instead of going with your parents to the 10-year route, you will get your indefinite in 5 years.
In 5 years.
Somebody will say, well, if somebody is born here and they've lived here 7 years, if they've lived here for another 5 years, that would be 12 years. They can get British. I'm not talking about people who were born here. I'm talking about children who have come here.
Mm-hmm.
So the children who have come here have lived here unlawfully for 7 years. They, in their own right, can apply with their families. Their family can depend on them to apply. Those children normally have gone to 10 years. The law has changed, and the law has changed very significantly in 2 parts. First of all, you remember about 6 months ago, Kofi Antubam called and asked a question that I made an application for my son. They refused the application under the 5-year concession because they said that the leave that he had was under the family route.
The family route, yeah.
Now that refusal, if he goes back to them, they will change it.
Because it's now become private life.
Yes. So whether it's family life, the 5 years is under family life, or private life, or a combination, it doesn't matter. They will still get indefinitely. This is significant. Because whereas the parents will go to 10 years, the child will get his indefinite leave in 5 years. What it means is that when they go into university, because at that point, let's say that they are about 12, 13, they now have got indefinite. In another 5 years, they'll be going to university. If they were to do the full 10-year route, they might not get indefinite leave before they go to university. So again, for me, this is significant as a parent because it helps our children to ensure that their education is not unnecessarily curtailed, and therefore it promotes integration, and it ensures that children who came here early in their life are integrated and they all have access to all the best things in the UK. So this is an update that I want to bring here.
Yes, so you've had the update, and definitely, if you do not understand anything, please seek proper advice and get clarification. You can do that with BWF Solicitors, and I will ask you to either visit them on the 4th floor of the Anna House, 214-218 Tottenham High Road, or call them and make or book an appointment, or make an appointment, as we would say, 0208 493 7340 0208 493 7340. Or if you're in Ghana, the Ghana office is on 055 589 5959 055 589 5959. Or in emergency situations, call 077 127 61884 077 127 61884. Now, Uncle Ben mentioned that we're going to look at the skilled worker route. Let me also say significantly that if we say the skilled worker route, we're not talking about care work route alone. There are other significant categories on that you can really look at. So now we're going to look at the skilled worker route. Changes have come, yes. What are the changes, I would ask? And those who are already here, the word we used when we were talking about the update was remain. So it means that people could be in here and the changes affect them. Those who are on the skilled worker route from July and are here, how do these changes affect them? Well, obviously, it's a direct question to Akube.
Okay, so what we want to do is we want to lay a foundation. So Ada, let's lay the foundation with 997, which is the immigration rules. The new one, HC 997.
997, yeah.
Let's use it to lay our foundation. It's it says policy paper, but it's immigration rules. Part of it will come into play on the 22nd of July, and it's quite significant. This is a PDF, so we can't jump to the section. But I just want you to look at something. Ada, let's go.
I think it should be able to take us there.
Okay. So now we've got the law, and then when you scroll down, let's scroll down. Let's go. It's about 134 pages.
Right.
Was 138 pages. Most of the things that you don't need. There's only a few that you need, which Kweku and the team have kindly reduced it to about 7-page flyer, which is what. But I just want you to see that this is the law we are going to talk about now.
Okay.
Okay. So they're going to review. There's a review period. The changes that they've introduced. Let's scroll. Adai. Stop. These are the changes. The intro 6.2 definition. Let's go down. Supplementary employment applies to everyone. Let's scroll slowly. The changes APP, SW. Anytime you see SW is skilled worker.
Skilled worker. Okay.
So the APP is applicant.
Okay.
So there's so many changes. Significant there is the income is changing from 38,700 to 41,700, and I'll explain to you why. The other significant part is that the equivalent qualification is changing from RQF, which is a regulated qualification framework. It's changing from sixth form equivalent to university equivalent. It doesn't mean that you have to hold university degree. All that it means is that whatever experience that you have, its equivalent must be to a university degree. That is why they've lifted the income from 37 to 41,700. Let's go down and pause. You can see that here APP SW7, SW612 substitute, it means change. They're going to change the immigration salary list, and they're going to add what we call a temporary list. This also is significant because the salary list is what replaced the shortage occupation. The shortage occupation was a painter, plumber, tiler, shop owner.
Yeah, I remember back in the day you listed all those and asked people, could you use those then?
Yes, and then the care route was also part. Now they've all been taken off. Let's go down. Let's pause. Now this is also significant. It says that the applicant is being awarded points under, but when it goes down, the applicant was granted permission as a skilled worker in rules before 22nd of July. We can now discard this and go to our flyers. We start with flyer 1. What is changing? So I mentioned that the skilled threshold has been raised. So the only job that will be eligible for skilled worker route will be RQF level 6, which is equivalent to university degree.
Okay.
I'm not saying you need to obtain university degree. All that I'm saying is that the equivalent must be as university degree. This is key because when you look at most of the jobs, 180 of the jobs are going.
That's significant.
180. So this means that around 180 jobs, mostly at lower skill level, will no longer qualify unless they are on the shortage list. Care, gone. Carpenter, gone.
Wow.
Mason, gone. Painter, gone. Seamstress, gone. Butcher, gone. Shop owner, gone. Now, all this
Baba is gone.
Baba is gone already. Baba the Baba is gone already.
Oh boy.
The salon must be the salon manager. Now, we intentionally put this there for people to understand the enormity of the changes.
Yeah.
So that people can start planning between now and 22nd. Let me use this opportunity to warn those who are on student visa, looking to switch to care. If you don't switch now, after 22nd of July, you can't switch.
You can't switch.
Let me also use this opportunity to tell those that we encourage to go and complete the local authority pool of people who have lost their sponsorship. It's gone. You're no longer going to be on that pool, but there's good news for you. And I will tell you the good news. The bad news is what we've told you. That pool is gone. Again, people have been using ancillary nurse, which is a code, I think it's a 1311, to circumvent the prevention and the ban of bringing dependents. That is gone. Home Office said you're abusing it, so it's gone.
Oh boy.
The other thing that I've mentioned already is a new salary list, which is gone up. It's gone up, it's going to affect everyone. So you can see that as we sit here, the countdown to the 22nd of July, when most of these things will be gone, has started. So if you've been given 60 days, you're a student, you are a graduate route person, you want to switch. If you don't get a switch now, it's going to be extremely difficult to get a switch. Let's go to number 2.
Okay. So then that would bring us the third point. There are no transitional protections for salary employers. For salary, employers must meet the new benchmarks. And we're talking about the updated occupation list, which is a new temporary list that has been introduced. The existing immigration salary list will gradually phase out as significant. Only roles on the list at lower skill levels, that is RQF 3 to 5, will remain eligible temporarily. And even then, applicants cannot bring dependents unless already in the UK before the changes take effect.
Absolutely. So if you're coming on a temporary shortage list, then unfortunately you cannot bring your dependent. And this will apply to almost all the areas. The other part is that people who are moving to a higher level, which is a RQF6, this will not affect them. If you're already here and you are on a care route, whether you're on a care route as a care worker or skilled worker, or you're working for a care company, this will also not affect you. Those people who are working for care companies as temporary work or ancillary work or supplementary work, if you've worked for that company for at least 3 months, this will not affect you. So again, it's too late to go and start your 3 months. But people who have worked with care companies for at least 3 months, this will not affect them. I did say that.
Please hold your thoughts there. You said the people who have worked with them for at least 3 months. So it means that those who are here and do not have enough shifts, those who have been told that the COS is curtailed and still within the country and still have not used the 60 days that will be given them, are the people you are talking about here?
Yes, they are the people. Now, if you've been given 60 days and you find another employer within 60 days, hallelujah.
Okay.
If you've not been given 60 days, the Home Office intentionally is not giving 60 days unless your employer reports you that they no longer sponsor you. But if your sponsor loses their license whilst you're being sponsored, the Home Office is not giving 60 days. They have intentionally paused it because of the new rules. Because there's something good in there for you, and we'll come to that.
Okay.
The good thing in there for you is that now all care companies cannot bring people from outside. 2, all care companies cannot employ new people who are not already working in the care industry.
Okay. So if you find yourself in here and you
have
some challenge one way or the other, they are saying that you are in a pool of workers.
You were in a pool, you're no longer in a pool, but the companies who want to employ people, they cannot employ any other person apart from you. So you don't need to be in a pool. All you need to be is that one of 2 qualifications. One, I'm working for a care company. I have a COS. The care company lost their license. I've not been given 60 days to leave. Another care company can employ me.
Okay.
In fact, they have to employ me.
They have to, yeah.
Or I'm here.
Once they have the vacancy and they need somebody in there, then they should be looking for people who are kind of stranded and employ them.
That's correct. Or I'm here. I'm a student. I do part-time with a care company. Or I'm a graduate route. I do part-time with a care company. Or I do full-time with a care company. I've done it for at least 3 months. I can be employed beyond after 22nd of July.
Okay.
So after the 22nd of July, if you've got a care company, the only people you can employ are our compatriots who are here without work. They are the only people you can employ after the 22nd of July. You cannot go and employ a student who's just finished. You cannot go employ a graduate route who's just finished. You cannot employ any of them. That is why I said, although they've closed the pool, there's still good news. Now, there's not a pool where you have to go and put your name. Now, the people have to come and look for you. And for me, that is very significant. Let's go to Flyer 3.
Okay. There are no transitional protections. We look at this one, which is point number 4, care sector impact. Overseas recruitment of care workers and senior care workers will stop for new overseas applicants from July 2025. Those already in the UK can still switch into these roles until July 2028, but only if they've been employed for at least 3 months by a licensed sponsor or they have a pending application which later was successful.
Yes, so this is what I spoke about. So if somebody is here as a care person, but they've lost their job, you can employ them after 22nd of July. If somebody is here as a student or as a graduate route person, and they're doing part-time in a care company, and they've done it for at least 3 months, and you, the person that they're working for, you can employ them after 2020. If somebody was issued a COS and they made an application before 22nd of July, and the application was not decided, but it was decided after the 22nd of July, if the application is successful, they can continue. If you give somebody COS before 22nd of July, but they don't make application by 22nd of July, you cannot employ them. And those are the parts that we want to talk about. We can go to 4.
Which is point number 5 we have on here. What does this mean for you? Akube said there's good news. So let's see what there is in there for people. Already on a skilled worker visa, you are safe for now. Transitional protections will allow you to renew or switch jobs even at lower skill levels without being affected by the new rules. Planning to apply after July? Listen to this. Make sure your job offer is eligible under the new RQF level 6+, and that's the criteria. And we also say, or it should appear on the revised shortage lists. Employers and applicants must also prepare for updated salary thresholds. There are no grace periods. One is saying transitional protections here. One is saying no grace periods. What is that?
For the money part, because you're now supposed to have a qualification which is equivalent to university degree, we cannot pay you a lower rate.
Obviously, yeah.
So you have to be paid 41,700. So if somebody came to me and said, lawyer, I want to do self-sponsorship. I want to set up a shop. I want to be a shop manager. The first thing I want to ask you is that, can you pay yourself 41,700? If you cannot pay, then we don't even start a conversation.
Yeah.
So that's one. Now they've created a new shortage occupation, and it's in the PDF, which we will go and look at. It's a long list. I don't think we need to look at it today. It will be too much for people. But what it means is that there is protection for people who are already here, not about money, but about changes to work. But the money, there's no protection for you. If you're here and your qualification is RQF 6+, 41,700.
That's the minimum.
That is the minimum, because you're not doing the lowest qualification, which is RQF 3 to 5. Now that is O level to A level. And the income, we all know, care was 25,000. In fact, at the beginning, it was 22,000. Even with some people, it was 23,000, 18,000, and then it moved up to 25 for both senior and care workers. And then for other people, it went to 38,700, and now it's rising to 41,700.
So the point five, the first one, the first bullet point is saying already on a skilled worker visa. So it will allow you to renew or switch jobs even at lower skill levels.
That's correct. Bear in mind that with a skilled, the care route, their salary is always pinned to the NHS.
Okay.
Because it's government pay, the government doesn't want to pay that much. So you would find that although we're saying the minimum salary is 41,700 for care people, because they are still here, they are now here, and they are on 3 to 5, their salary will still be 25,000.
Okay. There's a lot of information we provide you this afternoon, but listen, don't you worry too much, because with time we will be picking them one after the other and explaining. So we're not overloading you, but these are things that you need really to know. So just stick around. Let's look at point number 6 that we put on, and that is bringing dependence. When the statement of change was in fact the white paper, so to speak, we were told that people cannot bring in their dependents anymore and the rest of it. What is changing? What we are saying is workers sponsored in occupations on either list at RQF levels 3 to 5 will not be able to bring dependents. This does not apply to occupations at RQF 6 or above, or workers sponsored in occupations at RQF levels 3 to 5 who are already in the skilled worker route and able to bring dependents before the changes come into effect. In line with the existing restrictions on dependents of care workers and senior care workers, these changes also exempt dependent children who were born in the UK or where the skilled worker has sole parental responsibility for them. Again, this is my young friend will say this is grammar. Please break it down for us.
Okay, so we know that the new temporary shortage route, the name is temporary. No dependents can be brought here. That's one, unless you are on RQF 6.
Okay.
We also know that as everybody's moving to RQF 6, our friends and family care people are stuck on 3 to 5.
2 to 5, yeah.
Those people who are already here and were here before April last year, they can bring their dependents. However, those who cannot bring their dependents, if they give birth to a child in the UK, or there is a child anywhere in the world for whom they have sole responsibility, they can bring that child.
Okay.
Although it says no dependents. But if a child is born to you in the UK, although it says no dependents, you can add that child to your application.
Okay. Then we look at the final point we made, at least for the purpose of today's program. We're looking at care businesses who can no longer use this to bypass the ban on dependents. So we're saying to prevent the Occupation Code 6131 nursing auxiliary and assistants from being used to circumvent these changes. A clarification is being added to confirm that this occupation code only applies to roles in environments where registered nurse roles also exist. Uncle Ben.
So human beings are dynamic. When you move them to point A, they want to go to point C. They find a route through point D to point B and then come to point C. So when they put in the ban for 6135 and 6136, care and senior care, and they couldn't bring their partners, every care company can say that I have a nursing ancillary, and they will issue a 6131. The Home Office have recognized that. You see, they picked up late because we started using this last year. Significant people are brought through that. They brought their partners. They've now caught up to it. So you can still use this, but it has to be in a role where you have a registered nurse role. So if you are a care business and you don't employ nurses, you cannot use this.
Yes.
That's
All
what it means.
right. Okay. Well, I know that you would want to ask so many questions around these. Uncle Ben and BWF Solicitors have been very gracious to us to break that down. The document is over several pages, over 100 pages, but they've broken it down so very well for us to be able to understand it and picked out the relevant points that really affect us. I know your questions are there. I know you have other things to put to Uncle Ben. So we're going to take a quick break, and when we come back, um, we will do a quick run through the posters that I put in. Then we'll pick your questions and answers. You can put them in the comment section down below, or either on Facebook at BWF Solicitors or YouTube at BWF Solicitors, Facebook at BWTV UK, and YouTube at BWTV UK. Or you can send a text to our text line 07399 208 468, 07399 208 468. And I'm going to activate the phone lines as well, 0208 493 7345. Remember, it's the community. And this afternoon, our resource person and guest is a senior partner of BWF Solicitors, Uncle Ben, Mr. Bernard Owusu, as he is known as. Stick and stay. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. So leave your comments in the comment section down below on Facebook and YouTube at BWF Solicitors and at BWTV UK. You can send in your text as well, 07399208468. Uncle Ben is here. And as I said, we will whisk through the posters and flyers of the changes and how they are affecting you. then we'll pick up your thing. So we'll start with, I think we'll start with the very first one. What is changing? Skill threshold is raised. Only jobs at RQF level 6 or above will now be eligible under the skill worker route. This means around 180 job routes, mostly at lower skill levels, will no longer qualify unless they are on a shortage list. And Commanders mentioned that there's a shortage list. It's got loads on it as well, but about 180 are gone. And I liked it. Our barbers are gone, shop owners are gone, kinky sellers are gone. If you have a salon, then it has to be a salon manager. So then some may be gone, but another level may be added to that. So if you want further details, yes, you can contact BWF Solicitors and we'll help you with those ones. Point two, we say new salary rules. Salary thresholds are being updated to reflect UK wage trend. This affects the skilled worker, skill up, and global business mobility route. Point number three. There are no transitional protections for salary, and that employers must meet the new benchmarks. New temporary shortage list is being introduced, mentioned that earlier. The existing immigration salary list will be gradually phased out. Only roles on those lists at lower skill levels, RQF 3 to 5, will remain eligible temporarily. And even then, applicants cannot bring dependents unless already in the UK before the changes take effect. Point number four says overseas recruitment of care workers and senior care workers will stop for new overseas applicants from July 2025. Those already in the UK can still switch into these roles until July 2028. A stitching time saves 9. So if there's anything, do it quickly. From the 22nd, 23rd of July until 28th July. If you have anything, please do that and switch quickly. But only if they have been employed for at least 3 months by a licensed sponsor or they have a pending application which later was successful. Point number 5. Already on a skilled worker visa, you are safe for now. Transitional protections will allow you to renew or switch jobs even at lower skill levels without being affected by the new rules. Planning to apply after July, make sure your job offer is eligible under the new RQF level 6 plus criteria or appears on the revised shortage lists. Employers and applicants must also prepare for updated salary thresholds. There are no grace periods. Remember that. Workers sponsored in occupations on either list at RQF levels 3 to 5 will not be able to bring dependents. This does not apply to occupations at RQF 6 or above, or workers sponsored in occupations at RQF levels 3 to 5 who are already in the skilled worker route and able to bring dependents before these changes come into effect. In line with the existing restrictions on dependents or care workers and senior care workers, so to speak, these changes also exempt dependent children who were born in the UK or where the skilled worker has sole parental responsibility for them. And finally, we said that to prevent the occupation code 6131 nursing auxiliaries and assistants from being misused to circumvent these changes, a clarification is being added to confirm that this occupation code only applies to roles in environments where registered nurse roles also exist. Further information, speak to BWF Solicitors, call us on 0208 493 7340. 0208 493 7340. Or you can call 077 127 61884. You can send a text or WhatsApp to that number as well. BWF Solicitors definitely are trusted partners when it comes to the law. So I'm picking your questions, your concerns in the comment section down below on Facebook or YouTube, or you can send a text or call 0208 493 7345. Well, Prof, yes, let's see. Fastidious Stalonzi. How does the law affect the skilled worker who's already in the UK and want to bring her wife to the UK? Her wife. Okay, well, his wife. But these days, well, some are very politically correct, so some of these things. But yes, we understand. We're talking about partner here. How does the law affect a skilled worker who already is in the UK and wants to bring their partner to the UK?
Well, of course, they are already here. So we know the transition provisions, they will not be affected.
Okay.
So the person is not going to be affected.
Okay. So let's go to the next one. Promise. Good afternoon, lawyer. Please, I want to know if I have a B1 English certificate and I've used it for all my application. And if changes come 22nd of July 2025, can I still use it for my naturalization?
Yes, they can.
Yeah.
Yes.
So promise you don't have a problem. Let's go to the line. I have somebody on here. We'll hold on with Alexis bit and come back. Hello.
Hello.
Good afternoon.
Good afternoon, my boss.
Yes, sir. How are you?
Oh, His Grace, all is well.
Oh, okay. Now you're talking boss. The boss himself is here.
Oh, yes, I know. But every boss have an assistant, and for that matter, you are in charge of that. So.
Well, I appreciate it. Thank you very much. Well, Uncle Ben is here. He's ready for your question. Please shoot.
Yes. First, I need to thank Uncle Ben marvelously for his service rendering to the community and the whole of the world, because what he is doing needs to be awarded by the Ghana High Commissioner. This is what is expected of them to do. They need to do the needful before things goes wrong or before I conduct demonstration, because he needs to be awarded for such act. Going to my question, I wanted to know, with the pre-settle for EU applicants, since a friend has lived with the husband in the UK for 3 years, but their marriage was constructed let's say some years ago. So with that years, as they were married over while she was in Ghana and coming to the UK to live for 3 years, can the composition of 5 years be okay to apply for ILA, or she still needs to live here specifically in the UK for 5 years before?
So the law change is a continuity of residence. So as you can see, with a continuity of residence, in any 5-year period, you can use 2.5 years. It means that the person must be in the UK. That's why they refer to continuity of residence. So the person should have been married, lived in the UK for 5 years, but they can only prove 2.5 years of the 5 years. The law says that it will be acceptable.
Did you get your answer all right?
So with this, if they have for the marriage and for the stay has been fine, but then she has lived in the UK for 3 years, would that be okay to apply?
No, because she didn't come to the UK 5 years ago. She came to the UK 3 years ago. The requirement under the law is that you've lived in the UK for 5 years. But we know not everyone can show residence, unless she's going to say that she's lived here for 5 years. But if you're saying she came from Ghana, she would have come with a family permit, which shows that, of course, she hasn't lived here for 5 years.
Oh, okay. All right. Thank you so much.
Well, thank you for yours as well. You can send a voice note, as I mentioned, to 07399208 or you can call, as our brother has done, 0208-493-7345, or leave it in the comment section either on Facebook and YouTube. Now, let's pick our friends one before we pick that question. Yes, Alex. Will the new law apply to EU nationals who have lived here for 5 years but cannot provide evidence of stay?
Yes, so the law is specifically for people like this who have lived here for 5 years, but they can only show 2.5 years, which is 30 months, in any 5-year period, which is a 60 months.
Okay. All right, Alex, that's your bit. We go to the phone line again. Hello.
Hello. Good evening, sir.
Good evening, boss.
Welcome, sir, Uncle Ben.
Thank you.
Yeah, I have 2 questions for you, sir.
Go on.
First question is, I'll be applying my indefinite leave to remain next year, January. But I'm a kind of person, I always do my things earlier before the deadline. So I've already done my B1, which was about last month ago. So with this new law that's gonna take effect, will it affect me?
Which law
Like
are you
even the
referring
new
to? Which law?
but no, the change for the English test for the
Who,
indefinite
who
to
said there's been change in English law? So
yes,
everything we've said here today, we haven't said anything about changes.
yeah,
When
but there is rumors that there going to be like a B2 for you to use it to apply
that,
for your
that was in the
indefinite.
white paper. Since the
Okay.
white paper, there's been a statement of changes, which is built at the back of the white paper. There's nothing in there. It means that they may have dropped it. Okay?
Okay, and my second question is, I've got a new partner which she she has already divorced, so we are waiting for the marriage certificate from Ghana. So far, all the documentation is being assembled, just left with that the marriage certificate. Is there any way we can put in the application while we are waiting for the certificate in 2 weeks time?
So what you're saying is that you're married, you're going to marry someone,
Yes, please.
but the person is divorced.
Yes, please.
But
And the divorce
you haven't got the
certificate-
evidence of divorce.
No, we've got it. It's with me.
So what haven't you got? A marriage certificate.
Yes, they say it's gonna take about 2 weeks.
Why do you want
arrive.
to rush to make the application?
I think for the 16th of July, the new law that's gonna take effect because basically she's on a point-based system. That's what I hear that once she's on that.
I think you are hearing so many things, aren't you?
No.
Wait, what time did he join us?
I
don't know when he joined. Ask him because
have you been listening to the program?
I just chipped in.
Oh, you just chipped in. Okay,
Yeah,
okay. You know what I'll ask you to do. We've talked about so many changes and how it affects people. Okay, two things you can do: either take your time, watch back the program, or pick up the BWF Solicitors number, book an appointment, and come and see one of the lawyers. Okay.
Okay, sir.
Are you ready to pick up the BWF Solicitors number, or you have it already?
I have it already.
Please do. So book an appointment and come in so that you would have some dedicated time to get this explained to you, okay?
So before you leave, so that you don't go away with the misinformation, there is no change coming to skilled workers to marry people who are settled here from the 16th of July. There's no change, okay?
Okay, sir.
Okay.
Don't panic. You are safe, okay?
Mm-hmm.
Okay, sir.
Okay, all right. 0208493734. You can call in and get to speak to a lawyer. Nana says, I have a brother who's an EU citizen based in the UK. I wanted to know how much he needed to earn to marry someone from Ghana who is based in Ghana. Also, what else would he have to do to be able to bring her to the UK, Uncle Ben?
So, as you know, Nugget today, as they should have met him in person. So that's one. Two, he should be earning 29,000 gross, not net, gross. The person who is coming here must meet the language test. So they can either do English language at level A1, level A2, or level B1. The English language hasn't changed. If anything, they've added more countries to the majority English language speaking countries. That is the only change. The other thing that they need to do is that they have to show that they have an existing, the word we use is subsistent, but it becomes too complex. So existing relationship. So when you love someone, you text, they respond, you call, you travel and go and see them, you've got photographs together, maybe you're even planning to get pregnant, so there's evidence of that and all those things. They send money. You know, I don't know whether these days men who give the women money or the women who give the men money. But either way, they said, because I know women from here who send money to men in Ghana. But normally in our tradition is a man who looks after the woman. The money is being sent and, you know, they're loving each other. So that's fine. Then there's accommodation. You need to show that you've got at least one bedroom in a house that you can have. you need evidence of that in a tenancy agreement, a mortgage document, or some evidence of occupancy. And critically, we say that with the income in the 6 months pay slips, 6 months bank statement, P60, and a letter from your employer. And then finally, what I always say to people, if you want these applications to succeed, it's based on evidence. The evidence is what we've mentioned. The collation and the explanation is also critical. So you must always write a cover letter and tell your story, how you met, how loving it was, why the relationship has developed, why you've now decided to cement the relationship and formalize it. And usually when you're married, you want your partner to come and be with you under the same roof. And clearly that's what you're trying to do.
Okay.
Yeah.
Well, you can call in 0208-493-7345. I've got a voice note here. I've got some comments on the platform that we will pick. And we have another person on the line. It's been quite a busy afternoon. I appreciate that. Let's go to the phone line now. Hello.
Oh, hello. Hello. Good afternoon to you all.
Good afternoon.
Yes, it's me, KK.
KK.
Yes.
KK, yes. Yeah, go ahead.
Yeah. So, just a happy day regarding the concession which they clarify, which the Home Office is now, they put forward. They've applied common sense approach. Because that's what the concession, the children that was meant to help them, same time, it was banning most of them.
That's right.
You see, anytime I read it, I keep banging my head against the wall. So let's wait for the law to come into effect, and it's a happy day for everybody.
Well, the law starts this month, so
we're within July, so we just a few days away.
Yes. I'm the one who asked the question.
I know. KK, yes. It wasn't Kofi and Tubam, it was
it was KK. Well, KK, thank you very much for always participating.
Thank you.
You're welcome. Spread the news. All right. I've got a voice note here. Let's see what this person said here.
I hope it's okay. Mr. Mama Mena, the family friend, the masters, I was Scotland and Oba. Now, them are on any way and also. After Moba indefinite terms or the 220 free. Now, or a 10-year road to maybe. In terms of the 220th year way enemy. Now, Obanos, I'm saying the time on your short. So I 3 weeks short as a baby, sir. Now, Scotland, so no, Glasgow, I'm so more date 21 days. I was a birth certificate. And Bemani said, then come back the opposite application, that results on the indefinite on the eye, but they say, what my members are man. Now, say, obey me, I'll go ahead. I know about birth certificate not to once and our application. And I'm saying, because my many day on were students. Thank you so much.
Okay, so this person is asking, he's got a partner in Ireland. To him, the birth certificate, Scotland, sorry, the birth certificate should be done within a period, 21 days. He has a few more days before he can put in his indefinite leave to remain application and also wait for it to be successful or not. So the question is, should he go ahead and get the marriage certificate, the birth certificate, so to speak, birth certificate done before he puts in his indefinite remain application?
Well, national settlement has nothing to do with parentage. If a child is yours, there's absolutely nothing preventing you from putting your name on the birth certificate. Of course, the child will be born before you get your indefinite, so the child will not be a British citizen automatically under 1-1. The child will have to be registered once you've got your indefinite leave. So I don't see what should prevent you from putting your name. Yeah.
Okay. So yeah, our friend should really go ahead and do that, as it were. You can't just say that my child can be registered and given a birth certificate because I'm waiting for something. Don't wait. A stitch in time, they say, saves 9. New significant changes to the skilled worker route is what we have discussed this afternoon and how it affects those already here. And if you have any question on that, you can send that along, or you can put any other question in the comment section, send a text or call in for us to consider that. Uncle Ben is here to help you answer all that. With the new rules, can a skilled worker who's already in the UK bring her dependent from Ghana? Facetious or facetious? I think we have actually addressed this, but maybe for the benefit of somebody else who has just joined us, we'll have a quick clap at this.
Oh, yes. So people who are already here are protected. They can continue to bring their dependents if they came here before April under the care route. April last year, I mean. So they can continue to bring them. Yes, that won't change. Bear in mind that the Home Office said the shortage occupation they've created, that's one part, but also those who are already in the care route, they will continue to 2028, which is 3 years away. Now, if you have something doing, please do it now. Because they said they can chop and change
anytime.
at any time. And for me, because immigration has become such a hot potato for politicians, where you've got Nigel Farage, whose rise to fame is to belittle people who have created the economy and the infrastructure of this country, then clearly, with the language of our Prime Minister, Starmer, who is a very decent person, almost talking about the rivers of whatever it was, the previous language of, I forgot what the name of this person is. It's getting difficult. Now, who would have thought that Labour will bring in such a raft of new laws just to curtail the rights of people to bring their partners in relation to the 29,000, where the Migration Advisory Committee have told him that 29,000 is too much. Yet our dear friend and mother, which is the Secretary of State for the Home Office, is continuing with that. That tells you that there's not going to be any concession anywhere. And clearly people who are now struggling, I've got people calling me, they've got 60 days. What can they do? What I tell them is that you need to decide whether this country is for you or you want to go back. But again, if it's for you, then you need to do all the right thing to make sure that you can stay. And also, we are where we are because of some abuse in the system. And we don't seem to learn. And when I say we don't seem to learn as a people, I'm talking about the businesses that we obviously know that have led some of this abuse. So it's important for all of us that as we ponder over this raft of changes between now and 22nd, how many weeks is it?
Today is the 5th, so we've got 17 days.
17 days. That's about 2 weeks and 3 days.
2 weeks and 3 days, yeah.
Okay. Now, there are things that you can do, and I always tell people that please, when something is critical, you don't take it to someone to do try and error. Frank was telling me recently, a skilled worker who had 60 days went to see somebody that he thought was a lawyer. You know the application the person made for him? Asylum application.
Oh, gosh.
And they've been called for an interview. I've got at least about 7 of those cases call me over the last few days. And for me, it's not the best, Once you're shifting...
was the person just trying to buy time or what?
Well, buy time, not with asylum.
I don't get it. Why do you do the wrong thing for the person?
Yeah,
wasting money, time, and everything.
Yeah, and they take money. These things are not cheap. As I sit here, there's a gentleman whose advisor took a lot of money from him. I've got some of the money for him. She's promised to pay the rest, I think, this month. I think I need to follow up for the money to come. There's so many quack people out there. And the normal thing I tell people is that, you see, when you go to somebody who's desperate, or you are desperate, the person is also desperate. They want money to go and give their wives and girlfriends chop money. Because he's not a lawyer, he doesn't have a regular income. So in the whole year, he might see about 10, 15 people. If he lets you go, how is he going to make his money? So he will tell you all the fantastic story in the world. And it will convince you because you're desperate. Gosh. And when people are desperate, there are things they do and later they regret. Some of these things, when you get in there, it's very difficult for us to disentangle you from the whole process. There's a case I'm dealing with, of asylum, EU, and Kweku, it causes all sorts of problems. So my advice to people is, if you want advice, there's so many Ghanaian lawyers around, so many of them, a lot of them, where you can go. And they are lawyers. They are solicitors. They are lawyers. So it's not everybody who calls himself lawyer. If you ask somebody what's your name and they say, my name is lawyer Ben, run away. Because a lawyer doesn't refer to himself. I don't call myself lawyer Ben. Yes, people call me, Kweku will call me lawyer Uncle Ben or lawyer Ben. My colleagues will call me lawyer Ben. But I don't call myself lawyer Ben. It's because it's not my name. And when I see other lawyers and they're training people and they put lawyer so when the person is a trainee, again, it's a culture. Because even these days, when people are engineers, we put ING, engineer, so and so. Because I remember when my dad died and somebody said he was going to put lawyer on the obituary. I said, please. If you won't, no, my name is Bernard Uso. The best you can do is put Mr.
Mr. Yeah.
Put Mr. I'm not a doctor, so you can't put a doctor. These days, everybody's called doctor. So put Mr. Bernard.
People are just using honorary titles
to
just run themselves, and it's ridiculous. Anyway, 0208, we'll take a last call here. 0208 493 7345. Hello. Hello? Yes, thank you for holding on for a while. Please go ahead.
That's fine. That's no problem because I'm happy about what is going on. All right. I'm Steven. I want to say a big thank to Lawyer Ben and then the team for the good job, the hard job. I always say that Uncle Ben is there for us. It's not there for anything because as we came here, we have noticed the good job. All right. So I want to ask something small. I don't know if I can turn it into tree. Can I?
Yeah, go ahead. Go ahead. Yes, go ahead.
All right. So Uncle Ben, me to say once and now what people know can say obi abahano mo I think this is the nya na na wo boso de but no ka say so bi bakrum hanam or because we sunanka 5 years about 10 to 10 years. My name say be I akoye mra no awie na say I am na awie dia I was see no then I say
Ohene semra bi aba obete nti wunya nte we ho a enye mra why 10 years no mo ka ya no sa white paper na omo de ho law aba no omo mfa mbe nti yemfa de omo aba no ne mfa no nya adwuma why
Uncle, thank you so much.
You're welcome.
And second last one. Mr. Mema about one about now in office in terms of directing with different lawyer, but me professor about and he as I say to see no person or your application man my brother. But me no can say 3 months, 2 months me was a Sunday juma, but when you mouth from ye in the brown start adwuma foforɔ no ɔbɛtumi start application na
wo sister ɔyɛ den ama wo brother
na nka pɛsɛ application na ɔkɔfa no ba
sɛ den
menka ne sɛ okay And then maybe I think I may about on that paper cut as no 18 come of
Mate. So why would you say that? And actually, right.
Okay. Right. Well, yes. What basically my friend is saying is that he needs to book an appointment to see Uncle Ben so he can give him some further details for them to be able to help him with that. Daniel Opon, good afternoon. Can you please ask Uncle Ben I have done my new B1 English test certificate last one. I'm waiting to use it for my indefinite leave to remain next year. Is it possible to use that? However, can you throw highlights a bit on the English test, the B2?
There's no B2 for people who are on the private life going to indefinite leave or family life going to indefinite leave. There's no B2, it's B1. B2 is a higher English for doctors in this country. The previous white paper proposed that for skilled workers and some people, they might want to look at introduce B2 for them. They haven't done that, so I won't spend time on it. When it came, we spoke about it. We alerted people. It seems that the noise is calmed down, and therefore we don't find that in the current law. So there's no B2 anywhere.
Oh, okay. All right. I believe they do listen to us, don't they? Anyway, we pick Jeff's bit quickly, but I want to just bring your mind to the nugget we had earlier on appendix relationship. Is that what it is? Yes. Applicants for entry clearance to the UK or leave to remain in the UK as a spouse of a person present and settled in the UK must meet relationship requirements. One such requirement is that the couple must have met in person. A spousal application will be refused if the applicant cannot prove that he or she met the sponsor in person. Now let's take the question that we had. Then after that, we take a quick break. No, I'll come back to this. There was a comment or a question for Uncle Ben. Let's pick that one quickly. Then when we have taken the break, we'll come back to my friend was told that after a year of having 10 years resident card, he can apply for naturalization. Apart from the life in the UK and English test, which he has passed, what else would she need to do, Uncle Ben?
Jaffa Kusi, I'm not sure who told your friend that having a 10-year residence card naturally qualifies a person to naturalize as a British citizen. There's nothing like that. You're not the first person who's asked me. And that's why we keep saying that we should try and avoid people who say things without basis in law. For you to get nationality, you need to have indefinite leave to remain. So the fact that you've been on the 10-year route, unless what you're saying is that the person was on the 10-year route, they've now got indefinite, they've waited for 1 year, and they're going to apply for nationality. That is the sequence. You're on a 10-year route, you apply for indefinite, your partner is not British, so you wait for another 1 year, you apply for naturalization. You've got your English, you've got your knowledge of life in UK, you have your mother's name, date of birth, where they were born, father's name, date of birth, where they were born. If you're employed with your work details, address, telephone, email, 2 referees, ideally I prefer 2 British citizens, their passport details, their email, their telephone number, their address, their profession, their relationship to you, and if they've lived at the address for less than 3 years for partners or 5 years for non-partners, then their previous address. Once you've done that, you upload all the documents, you then go and do your biometric, and within a few months, they will call you to go to a ceremony. What a ceremony does is that it will afford you the opportunity to be presented with your naturalization certificate, which will then entitle you to apply for a British passport. So those are the sequence of events.
Okay, I've got one here that came on my phone, so let me quickly pick that one up. A friend went to Ghana last year, met a lady. After he returned, he wasn't so sure about her, so there wasn't any form of communication. He is gone again now in Ghana for about a month now. seriously in love and wants to marry her before returning, is there any advice to him in terms of future applications to bring the lady here?
Well, I'll say they should document their enjoyment um, and take a lot of pictures, um, make a lot of memories,
Mm-hmm.
and then when it comes and she wants to apply, she can use all those evidence to support her application.
Well, create the memories, make them good, and of course, show that at least for not like my friend who I'm going to refer to now, you would have met the person, and you can do that. Well, in any case, we're still on the community and the law, and I mentioned earlier on that Ahmed, who lives in Dubai, while Amina lives in London, have met, and they have done their marriage arrangements and actually executed it. They met on a dating site in January 2024 and started a relationship some 5 months later. After a period of chats and video calls, as I said, they soon discovered that they both come from Ghana and have a lot of things in common. Excited about their common heritage and desire to settle down in marriage together, they informed their respective families in Ghana about their intention to marry. In March 2025 this year, they married under Ghanaian customary marriage laws and they were issued with a valid marriage certificate. They also obtained a statutory declaration by their family representatives, a letter from the Judicial Service and the Ministry of Foreign Affairs in Ghana. Despite their desire to meet, the couple have never been able to meet in person, nor were they able to attend the marriage ceremony. As Amina has indefinitely remained in the UK, she sponsored Ahmed's application for a spousal visa so that he could relocate to the UK for them to start a family. The application is still pending. So I'm asking the question, what would be the likely outcome of Ahmed's application? Would it be one, it would be granted under Appendix FM because he's a spouse of someone who did definitely remain in the UK? Or two, it will be refused because they did not obtain a letter from the Ghana embassy in the UK? Or three, it would be granted because their marriage is valid in Ghana and so accepted in the UK? Or could it be four, it will be refused because Ahmed and Amina have never met in person? Think about that. I'll take a quick break. When we come back, we'll look at your answers. Then I will push them all to Akuben to find out which one is correct. Will it be one, two, three, or four? It's still the community and the law. Okay, we're back and we would want to get your answers now. Would it be one, two, three, or four? Let's see. How many do we have now? Alexa says it's number four. It will be refused because Ahmed and Amina have never met in person. Thanks, Alex. Next one here says that the partner has indefinite leave to remain and Ahmed meets the criteria to apply for visa. So it will be one. It will be granted under Appendix FM because he's a spouse of someone with indefinite leave to remain in the UK. Now, the Akko thinks is four. It will be refused because Ahmed and Amina have never met in person. The next one we have Prince Teria thinks it's number four, saying here, thank you, Prince. We move on to the next one. Thomas Boabing also thinks it's number four. It will be refused because Ahmed and Amina have never met in person. Hagar AJ thinks that it's one, it will be granted under Appendix FM because he's a spouse of someone with indefinite leave to remain in the UK. Next one says number three. Number three is talking about, can you push it up a bit for me so I can read number three? Yes, it will be granted because their marriage is valid in Ghana and accepted in the UK. Abena Boateng, number 4. Okay, Abena, thank you. Maxwell Opoku thinks number 2 refused because they did not obtain a letter from the embassy in the UK, Ghana embassy in the UK. Okay. Tilly Duma says number 4, it will be refused because Ahmed and Amina have never met in person. I think I'll take the very last one because of time. Abigail Boachi says it's number 4. I think number 4 seems to be quite popular. Okay, let me push everything to Uncle Ben, as I said, and find out. Ahmed has found love. Amina is settled, wants husband to join her in the UK. Application is still pending.
Well, so they've done everything right. They love each other, which is important in marriage. They have obviously done the customary marriage, again, which is what we advise our people if they want it done quicker and neater. But what they have refused to do is that on Monday, a nugget was posted, and I want Adai to show the nugget. The nugget says that if you apply under Appendix F, not under EU law, under Appendix F, under Appendix FM, you have to show that you met the person. And it is critical because they want a bond to be built not on photos and on enhancers and on screensavers where people can use videos to cover all the portals and everything. They want you to meet, because when the fire or the engine sparks in person and it's not from a distance, it means something. It shows dedication, it shows devotion. If the person traveled to see you and spend time with you, it also shows intention. And all this are inbuilt to protect both parties, really, because as you know, the law before was that when you marry 1 year, you get indefinite. They changed to 2 years, you get indefinite. They changed to 5 years, you get indefinite. Now you see that a lot of relationships are breaking down, even in the 5 years. They're even looking to change that to 10 years. Of course, that didn't appear in the law. And the requirement to have met is a major requirement. They don't need a letter from the Ghana High Commission because the application is entry clearance. The fact that they're doing it under Appendix FM, the fact that he's got indefinite leave, it's all important, but it's not the most important here. Again, if the marriage is valid in Ghana, it's important because it has to be valid in Ghana for the UK to accept it as valid. Again, it's important, but that's not the most important. The most important is therefore number 4, which is that because they haven't met in person, it's very unlikely the application will be allowed and it will be refused.
Yes, Uncle Ben has just mentioned the answer to this week's question is number 4. Ahmed's application will be refused under paragraph RWP 6.2 because he's never met a wife in person. A UK spousal visa application will be refused if a couple have never met before marriage. I will ask maybe a follow-up question. Is there a remedy for them?
Well, the remedy is to go and meet.
Okay.
That is the remedy. The requirement to have met is not to have met before the marriage, because when you look at that, it says that they should have met. And I would suggest that they always go and meet. In fact, when clients come to see us, the first thing we ask them is, have you met the person? And somebody will go and meet the person and conduct the marriage. That is acceptable, but you have to meet the person. And I suggest that he can go, they can have another ceremony at a registry. You know, it won't cost more than 2,000 cedis to have a ceremony. And then they can go home. Because for me, in our tradition, the biggest marriage is not the wedding.
The one that happened at home.
Yeah, it's the one that happened at home. because then you've got both families with understanding. And I know sometimes people are desperate. They want to do things quick because maybe they think that they're getting old or whatever. But bringing the family in also cements the relationship. But when there are issues in the marriage, you know, you call on your elders to deal with it. That is why if you look at divorce rate in the UK, it's higher than in Ghana. I mean, I know that, yes, people stay in marriages for various reasons. But for us, our culture is such that we bring families together. And it's key to keep it together. Yeah.
Well, we definitely have had a very good time with our senior partner, Uncle Ben, on the program, The Community and Law. And, well, the tradition of this program is that we do a quick summary of what we have discussed this afternoon. Then we draw the curtains down. Uncle Ben, what have we talked about?
So we've talked about the fact that there's no changes to the marriage route, and everyone who is here as a skilled worker, as a student, a dependent, or a main applicant, a sponsor, or a spouse, you can switch if your marriage is broken down. You've met another person. There are no changes. So if somebody tells you there are changes, there are no 16th of July. It's got nothing to do with you. Our focus is on 22nd of July. Donald Trump calls it Independence Day. Nigel Farage will call it Independence Day. But for us, it's a sad day for skilled workers, particularly for care people. You have been brought here by businesses. The only advantage I see is that these days, for people whose sponsors have lost their license, Home Office is not writing to you to leave. So you have ample time to do so many things. Somebody will ask me, so what can I do? You can go to university. You can go to school. You can marry someone. You can be someone's partner. If you're lucky enough to have a child, you can depend on the child. Or you can go and find another business because you're already here. Although you are on RQF 326, you can still continue because you are protected until 2028. Beyond 2028, there's no guarantee. So we should all look beyond 2028 and look at your visa, whether you will have indefinite leave by July 2028. If you're not going to have indefinite leave, they've told you that for the care route, 2028 is the last time that you can extend. Possibly when you extend in 2028, it will take you to 2010. From here to 2030 it's 5 years. So possibly you can have your indefinite leave. But we know that from the 22nd, care businesses cannot employ any other person who is not already in the care route. Thank you.
Well, need I say more? Thank you very much, Uncle Ben. After a long time, we've had him back with us, and it's been a wonderful experience this afternoon, helping us to clarify all the things and some of the misconceptions that people have thrown in the community. If you have any further details, please contact BWF Solicitors on the number 0208-493-7340. In Ghana, 055-589-5959. Emergency situation 077-127-61884. Or you can contact us or visit our social media platforms, X, YouTube, TikTok, Facebook, and all the other ones you can think of. BWF Solicitors, www.bwfsolicitors.com. Or you visit us on the 4th floor of the Honor House, 214 to 218 Tottenham High Road, Seven Sisters, North London. To you out there, thank you very much for your time. It's been good and real lovely feeling having you around whilst we are here. And to my production team, the trainee lawyers, the partners, and all the admin staff of BWF Solicitors here in the UK and back home in Accra, and also to Uncle Ben himself for allowing us to have this done, and also making time to visit us here live in the studio. And to my production team, I'm talking about Shilanka and Padmo Dudu, and my producer, Professor Ade, for their time and effort. My name is Ure Kufimpona. I'll be here again, same time next week. So do make it, and let's meet again. Good evening. you.